what to do if you've been arrested for a DUI here in San Marcos. Now, if you've recently been arrested for a DUI in San Marcos, or if you have a loved one going through the process, stick around. I think you're going to love this video. My name is Dod. I've been a criminal defense attorney here in San Diego County since 2004. My firm is Dod Law. We're located in downtown San Diego, and we have a virtual office up in Vista, California, right across from the courthouse where you're going to have court. Now, if you've been arrested for a San Marcos DUI, you're going to have court at 325 South Melrose. That's the Superior Court of California. It's the Vista branch, and that's where your court is going to be. So today we're going to talk about a Vista DUI if your case was out of San Marcos, right? So you were arrested in San Marcos. Now you're going to go to Vista for court. Before we get started, hit that like button, hit that notification bell. You can also subscribe to my channel. Again, my firm is Dod Law. www.dodlaw.com. You can call us at 619-814-5110. Now, you've been arrested for a DUI in San Marcos. You were on the 78. You were within the San Marcos jurisdiction. You were at Cal State San Marcos driving on campus. You were drinking at a park. You were coming back from a park in San Marcos. You're in a residential. You're at a bar, and you've been pulled over. You were involved in an accident. And if you've been recently arrested for a DUI, I'm very sorry to hear. Now listen, the fact that you're watching this video, it's too late now, right? Because the easiest way to prevent a DUI is don't drink and drive. But you're watching this video, it's too late. Let's discuss what the next steps are for your San Marcos DUI. Now everybody always wants to know, well, Dod, is my DUI a felony or is it a misdemeanor? Now, here in California, there's only 3 ways you can have a felony DUI. The most obvious way is, right, someone died. There's injuries involved, so death or injury. You have 4 or more DUIs within a 10-year period, or you have a prior felony DUI, but then you're arrested for a misdemeanor DUI. Your misdemeanor DUI is going to elevate to a felony because you have this prior felony DUI. So those are the only 3 ways that your DUI could be a felony. Now, most DUIs here in San Marcos are misdemeanors. So you're arrested, you're either at a sobriety checkpoint, you're pulled over for speeding, for weaving, for drifting, or there's an accident, you hit a parked car. Now you're pulled over and you're given a series of field sobriety tests, you do a breath test, you're taken to the station, you're arrested, you get released, they give you a pink paper, and you get your driver's license taken away if you have a California license. Now, the most important thing you need to do right off the bat on a DUI case in San Marcos, because time is of the essence, that pink paper that you have, if you pull it out right now and you look at it, about 3/4 of the way down, it's going to tell you that you need to contact a DMV. And you need to contact the DMV and schedule a hearing. If you don't, your license will automatically be suspended within 30 days. You can call our firm at 619-814-5110. We can handle that for you. We will contact the DMV. We will schedule your DMV hearing. And the most important thing is we're going to put a stay on your suspension, because if we don't do anything, that pink paper that you have is only valid for 30 days. If we contact the DMV and schedule a hearing, your license suspension will be stayed, meaning you'll be able to drive beyond that 30 days until we do the DMV hearing or until you're convicted in criminal court. Now, everybody always asks me, well, Dod, I had the San Marcos DUI. What about my license? Well, you are facing a license suspension. In order to get your license back in California, you're going to have to get something called an SR22. You're going to have to get enrolled into a program. It could be a 3-month program or a 9-month program, or you're going to put an ignition interlock device on your vehicle if you do not want a 30-day suspension at all. If you can live with a 30-day suspension on the 31st day of your suspension, you can go to the DMV. As long as you have your SR22 and you're enrolled in the program, you can get a restricted license. But there's 30 days where you can't drive, or you put the interlock on your car and you'll be able to drive without a suspension. So that's all DMV issues regarding your San Marcos DUI. Now, what about the criminal case? Now, with the criminal case, what's going to happen is you're going to get a court date. And typically you get arrested, you bail out, they give you a piece of paper and it's highlighted. Your court date will be highlighted and it'll tell you when your court date is. So you're going to show up to 325 South Melrose, the Vista Superior Court, and if you're going to be in Department 14, that's going to be your first court appearance. Now, if you do not hire an attorney, you're going to have to appear. And you're going to have to appear in Department 14, and that will be your arraignment. If you have an attorney, then your attorney could appear without you being present. So your attorney can appear without you being present if you do hire an attorney. So at Department 14, that's your arraignment. Now, what is an arraignment? It's your first court appearance where you're formally advised of the charges against you, and most likely you're going to enter a plea of not guilty unless you're given some sort of great deal where you cannot reject at that point. And then once you plead not guilty, the case is going to then go down the hall to Department 1 for a readiness conference. And between Department 14 and Department 1, there will be about a month and a half time between your next court date. And between those court dates is when the DA is going to have to provide your attorney with all the discovery, all the breath results, police reports, body-worn cameras, everything on the case in order for your attorney to properly prepare to negotiate your case and to fight your case. Now, what could happen at the arraignment? Now, on a misdemeanor case at the arraignment, there's a possibility, depending on your blood alcohol level and the facts of the case, the judge could impose certain conditions. They could impose a scram ankle bracelet. So you might have to put an ankle bracelet on during the pendency of the case. They could order you not to drive during the pendency of the case. They could order you to do 2 to 3 Alcoholics Anonymous classes during the pendency of the case. So those are all consequences that could happen at the arraignment with a not guilty plea and the case getting set for readiness in Department 1. Now, what happens when you go to Department 1? Your attorney is obviously going to negotiate the case. Now, what are the defenses in your DUI case? Now, several defenses. Number 1, what was the reason for the stop? Number 2, were all the proper procedures followed when they gave you the breath test? Were all the proper procedures followed when they gave you the blood test? If this is a CHP case where they got you on the freeway, do we have the video to corroborate what the officers are saying? So there's a lot of things we can look at when we're evaluating a DUI case. Do we have a possible rising blood alcohol defense? Because remember, the main issue in your San Marcos DUI is not what your blood alcohol level was at the station or on the side of the road. The main issue is what was your blood alcohol level at the time of driving. What do I mean by that? So let's say hypothetically you're pulled over at 7 p.m., but then you don't even do the blood test until 8:30, and your blood test at 8:30 comes back at a 0.07. Well, everyone says, well, Dod, I was under a 0.08. Well, that's correct, you were. However, what was your blood alcohol level an hour and a half prior to that? That's going to be the main question. And the DA's office is going to call certain experts, and those experts are probably going to testify that your BAC at the time of driving was around a 0.10 or 0.11. So that's how it works. So a lot of people think, when you get this San Marcos DUI, is if you, stall, go to the station, and all of a sudden your blood alcohol goes down, you're not going to be charged with a DUI. That's just a myth, with these DUI cases. So in Department 1, your case is going to either settle, continue, or your attorney can set the case for trial if your attorney thinks you have a case to fight. Now, what if your case is a felony? If your case is a felony, it's a whole different story with your San Marcos DUI, because in Department 14, when you go to your arraignment, there's a very high likelihood that you could get your bail increased, you could already be in custody, you could get taken into custody, you could get hit with an ankle bracelet, and then with the felony, it really all comes down to the injuries, the severity of the injuries. And your case is not going to go to Department 1 now. Your case is going to go to Department 6 for a felony readiness conference. And with a felony, you also have the right to a preliminary hearing. So if your attorney thinks there's some issues in the case, then your attorney will set the case for a preliminary hearing when they go to Department 6. So there are a lot of things that, a lot of moving parts in a DUI case, whether it's a misdemeanor whether it's a felony here in San Marcos. Remember, if you have a San Marcos DUI, your case will be in Vista. My firm is Dod Law. If you want to talk about your case, give us a call, 619-814-5110. 8334 Law. You can go to our website, www.dodlaw.com. Hit that like button, hit that notification bell, subscribe to our channel. Have a great day.